Going into more details, let's look over the ownership and protection rules provided by Bulgarian law. AI and software in general are considered literary works under Bulgarian law, which is in line with the solutions adopted by a lot of countries around the world. In principle, the author, which is always a natural person, of the code will hold the copyright over the AI. As an exception, the Bulgarian Copyright Act explicitly states that the rights arise for the employer unless the employment contract states otherwise when we're talking about software. This rule applies only for software, however. It does not cover a case that is becoming more common in Bulgaria, software created by freelancers. For such cases, the freelancer shall be the owner of the software they have written, unless the contract for creating the software stipulates otherwise. As a result, for companies, it is extremely important to regulate the relations with programmers very carefully and avoid the situation where the AI is owned together by a number of freelancers or even employees due to the fact that the HR department has overlooked a seemingly harmless clause in their contracts. The duration of the protection is 70 years after the moment of publishing. So any AI will be protected long after it is incompatible with any hardware on the market. Issue starts to arise when applying the protection of literary works towards the use of software. Bulgarian law is adapted to the standard relationship between author and publisher, so use can be licensed only for a term of 10 years as a measure granting the author some independence. However, this rule applies also to end users of every type of software, which creates problems when the end user has the intention of using the said software for a longer period of time. Of course, the matter can be resolved at a later point by extending the license. But practice shows that this creates uncertainty, especially when the end user expects to have an asset for a longer period of time. For literary works, this matter is resolved easily. The rights of the author and the moment of the sale of a hard copy of the book, which is a solution that can be applied with some prejudice to CDs, DVDs, etc., but not to digital copies. But when dealing with AI, issues arise without an analog to literary works. The Bulgarian legislation contains some specific provisions concerning software, especially the rights of end users. However, these provisions deal only with the most basic issues, such as the specific right to activate the program or even decompile it and change it for the purposes of compatibility. These provisions do not reflect the way software companies currently work. AI, like any modern software, must be updated, upgraded, and maintained constantly, and it must be compatible with the hardware and software it works with. Updates, upgrades, and maintenance can, of course, be done by the company which is holding the copyright. Also, the end user might have the right to change the AI, unless the license agreement explicitly forbids it. However, involving a third party should be considered a violation of the copyright because the end user cannot share the algorithms unless explicitly authorized to issue a license to the third party. Such matters must be resolved at the beginning of any long-term partnership, and the setup of an AI should be exactly that in every case, but in practice this is not what happens. They are left unregulated until these relations turn into a problem. And if the company providing the AI has not settled the copyright because relations with the freelancer have remained unregulated, for instance, the matter might become nigh on impossible to resolve. Such cases are slowly making their way to the Bulgarian courts and will become more common in the future. Things get complicated further when the algorithms created by an employee bring huge profits to the employer, which is the goal of any business, of course. In such cases, the employee has the right to claim an additional remuneration to make it proportional to the employer's profit in accordance with the Bulgarian Copyright Act. This right is still rarely claimed and would be difficult to utilize when the AI is created by a larger team, but it leaves a potential conflict between employer and employee and further complicates the already difficult HR aspect of the IT business. And the actual problems AI brings to the software market are only just appearing in the legislative discussion in the EU level. Concerning ownership, two such problems arise from the very nature of AI. First of all, an AI can grow more complex while operated by the end user. So who would be holding the rights over the developed AI? And who would hold the rights over any other algorithms created by or with the help of the AI? The resolutions of the European Parliament from October 2020 have finally set these questions on the table, but there is still a long way until legislation on the matter is adopted. An AI can get additional protection by the law if it is patented, which under Bulgarian law would be possible only if the AI is a part of a larger invention meeting the requirements for patent protection, or if it is considered a trade secret due to the way it is kept confidential. These two options would provide additional options for protection, but are incompatible since a patent is made public and a trade secret is protected only as long as it remains confidential. The patent would be the better option, granting more rights and not requiring the holder to keep the invention secret. But it is more difficult to obtain given the requirements for originality and inventive step. The protection of a trade secret is easier to get because it depends entirely on the holder of the AI to take measures, including adequate non-disclosure clauses in the respective contract to keep the information confidential. In both cases, protection will not be granted only against copying, modifying the algorithms, but also against using their underlying principle within some limits, which makes it more valuable than copyright. This additional protection in case of a patent has an impact on the relations between the company owning the AI and its employees. If the invention is created under an employment contract or with the resources of a company, then that company shall be the holder of the right to patent the invention. However, in case a patent is issued, the inventor, who is always a natural person, will have a right of an additional remuneration similar in case to the rights of the author. However, unlike the author, the inventor enjoys more clarity as to the amount of this remuneration. It will be a percentage of all profits from the invention, the value of the latter, but also considering the resources provided by the employer, both material and non-material. The regulation of databases is a little bit more up to date, whereas the ownership over the database is always for the company which has invested in gathering the data. The database is protected for 15 years, and the timer is reset every time the database is updated significantly. The owner can sell the database, and the current wording of the legislation implies that this would not be equal to transferring the copyright over it. A problem arises when the database has been published legally, because every person who has gained access, even without committing an illegal act himself, can use it. So databases must be kept secret, similarly to know-how, in order to be protected under the law. As above, marking them as confidential might provide some additional protection of the database, but the rules of non-disclosure should always be expressly negotiated with any party getting access to the database.